Okay, it is about 7:03 p.m. Central Standard Time, Monday, October the 18th, 2021. And welcome to week number three. Three. Um, this is the halfway point, and it seems like we just get started. Yeah, we did just get started, but that's why it is so important to stay on task and on point because of the fact that the quarter goes so very fast. So I'm going to go ahead and share my screen. Most of you did pretty well with the written assignment. Um, Probably the issue that many of you had is that uh, you didn't put the notes at the bottom of the slides. And those who did put notes, they only had like one line or something. The notes are supposed to um, demonstrate, it's almost like a footnote. The speaker notes were like footnotes that we used to have when we wrote papers back in the day before APA, when I was in college and law school, where what we did was we cited the source in the body, put a number next to it, and then at the bottom, we would put an elaboration on that or an annotation. That speaks more to the language that you guys probably understand. An annotation, and what that did was provided support for the content in the body of the slide itself. So that's an assignment that you guys don't really have to worry about doing any more PowerPoints. The rest of them, that my recollection is, including the one for this week, is also going to be in a Word document. So, but we're going to talk about that in just a few minutes. So let's check and let's look at the calendar first before we go into anything. See where we are. As I told you, this is week number 3. And you see the course began on the 4th. We're at the 18th. Your lectures today, your initial post is due tomorrow night. Your reply post is due Saturday. And then your written assignment is due on the 24th. And as your live classroom phrase is. And then just to jump ahead and show you that actually coming up in a few weeks, we'll be kind of, as they say, getting a wrap. As you know, I'll go to November so you can see we're almost halfway there. You'll see that when we get to November, the course ends on the 9th. But one of the critical things for you to be aware is that on the 1st of November, there will be 2 lectures. There will be one at 7 o'clock, then we'll have a half-hour break, and then we'll go into the week 6 lecture. And the reason being is because of the fact that since the course ends on the 9th, it would make sense to have a lecture on the day before class ends, provide you with discussions or details about week 6. So I could have moved it to another day, but I said, no, I might as well give you a good chance to have plenty of time to deal with the materials for week 6. So therefore, that's why we'll have 2 lectures there. But the course absolutely ends on November the 9th. That's just a reminder for you. Okay, let's go back. Let's take a look at the announcement for this week. So in week 3, the 4th Amendment and government authority will be the topic, and you would read chapter 9 of the text. I provided the PowerPoints for you. And then you're going to be familiar with Terry versus Ohio. This article in here, Terry versus Ohio, 50 years later. And if you click on it, it will actually open up the article, and you'll be able to see this commentary. And it's not that long. So you're going to read about, do you remember the good old Terry stop, right? The stop and frisk. And then the Colorado Springs Police Department General Order dealing with search warrants, forced detention and arrest, law enforcement guide, search and seizure and arrest, state of Connecticut, reasonable suspicion research starter, and the Fourth Amendment research starter. And then the search warrant requirement, and then the probable cause starter. These are some exceptional resources that will help you to deal with the Fourth Amendment and to deal with probable cause as an issue. And we're going to talk a little bit about reasonable suspicion and probable cause tonight. The discussion assignment is reasonable suspicion. We'll talk about that then. And it tells you again when your posts are due. And then your written assignment, search warrant, exceptions. Now, you guys should already have some information that I sent you about that to enhance what you have already. I sent that to you. I sent you some extra stuff that I didn't mean to send, but there was an assignment that I had in the old constitutional law class that I created myself, and I sent you that more so to provide you with some cases that would provide search warrant exceptions and to list several of the exceptions to a search warrant. And then you know about my motto, adversity is the springboard to success. Very interesting discussion post last week. You know what? I don't think you can see, you can't see what I'm looking at. I just thought about it because I didn't share. No one told me, but you couldn't see it. Here it is. My bad. Okay, so going back, bear with me while I go back. The calendar again. Go into the month version, and you can see now. Anybody in the future, did I forget to do that? Because I'm getting used to this new way that they gave us to share that we had differently before. So your live lecture is taking place today, week 3, your initial post, and then your reply post, and then your live lecture, and then your written assignment. And then going over very briefly to November, you will see that on the 1st of November, there's the live lecture at 7, and then the second live lecture at 8:30. That will be the week 6 lecture, and the reason being, as I stated earlier, before I shared this with you, is that the course ends that week later, and it didn't make sense to do a lecture on the day before the course ends. I don't think you'd get much out of that. So that's why we're doing that on that day. Okay. Go back. And finally, let's go back to the announcements, because I showed you some stuff in there in our week 3 announcement, which you can take a look at yourself. But It talks about chapter 9 of the text, and then Terry versus Ohio. And again, if you clicked on the link, it opens it up. A very nice short article about Terry versus Ohio, frequently known as the stop and frisk. This is where reasonable suspicion comes into play in an 8-to-1 decision. So we deal with that. So that's some material to help you. And then Connecticut, and then the reasonable research starter. This is something to help you again. We're giving you sources to help you to try to understand the concepts. And here we go. Reasonable suspicion, and you know that, as it says here, the amount of certainty that illegal actions are taking place, and that the stop, the standard is less than probable cause. And the key thing about that is that it's based upon a reasonable officer. And then this is just a little blurb that you can actually take a look at. Very good explanation of probable cause, which I'll talk about a little bit more. And then same thing, Fourth Amendment, search warrant requirement, probable cause search starter. And as I said earlier, I sent you information that will help you to deal with this. And then I gave you the assignments here, so I'm going to get off of that now. Now, one of the things that I found was so interesting was last week's discussion discussion assignment. And I had a discussion with a student about it. And, you know, the exclusionary rule about, you know, the fact that the police officer came to, the detective came to the house to interview a suspect and then asked to use the bathroom. And then, you know what he did? He went to the refrigerator and opened it up. And so what happened is that the young man is arrested and taken into custody. And then the severed head is positively identified as a recent homicide victim. Now, because of the exclusionary rule and the sloppy police work, which I responded to in my discussion response to you guys last week, this presents a real world scenario that has happened where an overzealous police officer did not do the right thing. First of all, number one, he wasn't given an opportunity to conduct a search with, and there was no basis outside of getting a warrant. There was not any probable cause that he had to know about this, the crime. And look, it says he had a habit. He had a habit of routinely opening the refrigerator and freezer doors and looking inside. Can't do that. Can't do that. And so the sad part about this, guys, is that whoever that defendant would be could possibly walk based on that. And I asked several students if they could think of ways that it could have been cleaned up after he saw it. I mean, and I searched my professional experience in the many cases that I'm familiar with dealing with the exclusionary rule, because that's a tool that defense attorneys used quite frequently, of which I was for over 20-something years, and pretty good at it. And I came to the conclusion that, you know, he opened up a can of worms, and that evidence, I didn't see any way in the world that it would fit under the exception. He didn't get consent. He gave consent to go to the bathroom. If he now, for example, gave him consent to go to the refrigerator and get a sandwich, which I doubt if he would have, then he would have, that would have applied. Um, it didn't fit under attenuation. It didn't fit under, um, one student talked to me about plain view. I said, well, do you think the refrigerator had a glass door on it? I doubt it. And the bottom line was that it is quite clear that he opened the door because that's something that he usually did. But he botched the case by doing so, because the exclusionary rule protects the Fourth Amendment rights of people and protects you against unreasonable search and seizures. So, anybody have any comments about that? I mean, it could probably discuss you, but that's why we train law enforcement people to adhere to the rights of all individuals. I represented some police officers in some instances, and they had the shoe on the other foot, and I used the exclusionary rule to get some evidence that was taken improperly, and not used, not allowed to be used in the trial because they violated the Fourth Amendment and didn't fall into one of the exceptions. So it's pretty bad, pretty bad. I just look at a few comments. I'm gonna pick on Tasha here. If you can remember this from a prior class, if the officers did not have a warrant, snooping through the refrigerator and freezer is not allowed. Correct. The suspect invited him into the home, but you're not supposed to be snooping around while on the way there. The evidence is invalid because they didn't have a search warrant. In most cases, you could possibly lose your job or pay some heavy fines, probably get suspended. If the suspect didn't sue, you could easily lose your job, have to go through retraining rather, and other penalties for being such an unprofessional on an investigation. This is an excellent, cogent to the point post. There are always consequences to our actions, whether good or bad. If you would have stuck to asking questions, you could have easily picked up how he responded and worded something. He could have given you an indication that he wasn't telling the truth. It's always better to have a warrant before snooping around. Yeah, Tasha, unless it falls into one of the exceptions. So I'll use yours, but excellent and on the point. When I use these discussion posts, it's okay because everybody sees them anyway. But this kind of like nails it down. So what is he? Brian said. Let's see what he said. Yeah, yeah, yeah. They sure did, and they also knew that they had to. They didn't follow protocol in the process. So now, if they had a dumb lawyer representing the defendant, and it wasn't suppressed, because be aware that the way the exclusionary rule operates is that it would require the defense attorney representing the party to file a motion to suppress prior to trial, seeking to get that evidence cast out and not be able to be used during the trial. Couldn't even be referred to in testimony or anything else, because if it was ever used before the trier of fact, particularly a jury, it would result in a mistrial all day long. So yeah, he did. He did know it's bad. All right, guys. So let's move into this week. And let's look at module 3. And let's look at the written assignment first. Help you out here. Okay, so now these are all scenarios that are real. That's, you know what I like about these? I read over these. These are excellent. They're based on things that happen uh, probably during most of our careers as police officers, as I was for a while, and as a not law enforcement, but as a defense attorney, and then my friends who were prosecutors. So it says an officer stops a car for speeding. I'm just going to do one of them. The driver has a warrant for failure to appear on a misdemeanor battery case. Okay, so he finds a warrant for failure to appear on a misdemeanor battery case. The officer arrests the driver and searches the car. The officer finds cocaine in the center console. Which lawful exception to the search warrant applies? And or does probable cause or reasonable suspicion exist? Okay, so uh, that's a call that you're going to have to make. I think you might have some problems here with reasonable suspicion. Even though a crime, there was speeding, that was the crime. So that's a traffic issue that created it. And then the warrant for failure to appear in a misdemeanor battery case. Notice the kind of case. And the person is arrested and searched the car. So what they should have done was possibly impound the vehicle and then obtain a search warrant. But the bottom line is that, or they could have stopped it and asked the person, could they search it, and those kind of things. But the cocaine is in the center console. So the only way that that cocaine is going to be allowed as evidence is if you can find a lawful exception. We talk about those, and I've given you some examples there. So that's the way each of these you're going to do. Okay? You got 5 of them. A 3 to 4 page paper that discusses the correct exception to the search warrant requirement. If there is no valid exception applies, say why not. Support the rationale with appropriate case law. We've given you stuff. Cite your sources, including a reference page and a cover page. And I'm looking forward to seeing these papers, because I think this is a good a course, because you're actually doing things that you really should learn about. So if you, for example, a law enforcement officer, if you are a probation officer, parole officer, correction officer, work in corrections as Brian Presley works, you need to be aware of these kinds of things as well. Again, you get to the point that the essence of it is to make sure that the law is followed by law enforcement. If you're not gonna, you can't be a law enforcement officer and not follow the law, and you can't deprive individuals of their constitutional rights just to gain an arrest or conviction. That's the key. So let's look at the rubric. Everybody knows which column I want you to be in, but just to make sure, can somebody tell me what column that we're going to focus on in this, in discussing this? Yes, mastery. I don't even discuss the others because I told you this is A, this is B, this is C and D, and this could be F. So I don't waste time discussing. I don't even want to discuss proficiency. I want you to stand above the crowd. All right. So in each scenario, since we're talking about scenario number 1, an outstanding discussion of the applicable exception. And guys, you got a head start on a lot of material that we provided you in addition to that material I sent to you last week with comprehensive details on whether no valid exception and thoroughly supporting your position with appropriate case law. Those of you who are paralegals understand the importance of that and understand the details that are required in order to be able to substantiate your case. So I'm not going to repeat that for each one, but I am going to go down and tell you that credible sources are cited in APA format. In APA format, cite your sources. And please, 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 whatever you do, when you cite a case, please cite the official site, the United States Supreme Court, which what most of these cases are, or the state court, but cite it officially. And that includes the name of the case, that includes the first page, and then it includes the year in which the case came out. So, for example, if you were citing the Miranda versus Arizona case, you cite Miranda v. Arizona or VS Arizona, the number, and then that's the first thing, and then you type, you'd have the rest of it. So you know what it would look like when you see the source. I've given you some illustration examples, and then you'll see that also as you go into the assignment itself, and you'll see how we want you to cite the case. So it consists of the name of the case, the first number, which is the first page, and then I'm sorry, the volume. I'm sorry, my bad. The volume, or 384 US 436, which is the page, and then in parentheses 1966, which is the year that case is cited. So that's how you're going to make sure, very important that you do that. Now, you don't have to do that each and every time. You do that the first time that you use that case, and then you know yourself in APA how to cite it a second, third, or fourth time. But you do that for each original use of the case. Everybody got that? Pausing for responses. Everybody got it? Okay. Okay, good. All right. So you have no questions then, because like I said again, just this is good. I think I would find, I found when I was in school, if I had these kinds of things, these were like awesome, and it's exciting to be able to provide that information. Okay. So now let's get to the topic of reasonable suspicion for discussion, the good old Terry analysis. So you're going to explore reasonable suspicion and how it applies to suspicious people and vehicles. So here it is. You are a new law enforcement officer assigned to the night shift. You are watching for hand-to-hand drug deals outside a bar. You see two men on the sidewalk in front of the bar. One man discreetly hands another a baggie in exchange for cash. Both quickly walk away in different directions. The man who had passed the baggie is an adult white male known to you as John Smith. You've had prior contacts with John for narcotics related arrests, so you had a history with him, in other words. You watch John walk into the bar parking lot, enter a dark blue four-door vehicle, license plate blank blank, and drive away on the public. Now, explain and justify why you are able to stop John, or are you able to stop John? I'm not answering that for you because it's too clear. And his vehicle. Now, once stopped, what would you do next, and explain why you'd be able to frisk the interior of the vehicle? Now, here's the deal, guys. It was very smart for the police to not stop him as soon as he did what he did, but to continue to observe him until he went into his car. Why is that? Anybody want to take a shot at it? Why? Well, you're heading that way, but um, it was on his person. Okay, but no, I'm not. Okay, why was it wise for the police officer to wait until he got in the car before attempting to stop? Because somebody said because, just because, because what? Yeah, we know that part. Because what? Okay, here's the deal. You're going to discover what the parameters are for a stop and frisk, reasonable search. We're going to talk about that in just a few minutes. And when you get there, you'll have the answer to that question. But it was a very smart thing, and I'll refer back to it. But I'm going to let you think about it while we go through. So anyway, your initial post, of course, is due tomorrow night, and then your reply post is due on Saturday night. Okay? And those are the written assignments. Of course, you know, you have the live classroom um, phrase. Okay. So let's talk about what is probable cause. What is it? What is it that the court is basically saying that made it so important that it was included in the Fourth Amendment, the words, based up on probable cause? So the key thing is that as they say, the best practice is obtain a warrant before searching. However, as it says here, this is not really practical. So we start to deal with the issue of searches and seizures conducted without a warrant, um, based upon probable cause, supported by the Fourth Amendment exception. So the Fourth Amendment is a very important foundational tool for you to understand, and the concepts of probable cause and reasonable suspicion. Let me just say at the very beginning, um, probable cause is like almost like reasonable doubt. It means that you have enough evidence that whatever it is that you're trying to locate or the person you're arresting um, um, did it, and you have substantial support for it. On the other hand, reasonable suspicion is more of a protective mechanism. You're going to discover the Terry stop, and we deal with reasonable suspicion. You're going to be looking at stopping an individual because of the fact that you suspect that they committed a crime. Probable cause is you suspect plus. So I guess I should say you have reasonable suspicion, and then probable cause is based upon suspicion plus good evidence. So look at the essence of the concept here. It says the facts and circumstances before an officer are such as to warrant a man of prudence and caution in believing that the offense was committed. It's sufficient. And that's what I just said a few minutes ago. That you had good stuff in the Brannigan case. However, as the very name implies, probabilities. These are not technical; they are facts, and dealing with common sense. That's why it's so important to apply that in everyday life, and that it's not legal technicians. It's common sense. And then the Gates case, as the name implies, deals with probabilities. Again, probable cause. These are not technical, they are facts. So you begin to shape into your mind that probable cause is something that you know it when you see it. That's the way that it should be reached in terms of a conclusion, without me getting into the essence of it. Okay. And so you can't arrest a person except on probable cause unless it falls into an exception. And if there is no probable cause, the lower standard is reasonable suspicion. So this is temporary, though, to identify and question the individual. Again, you kind of get the feel of where I'm at, everybody. You got it? Okay, because it's such a easy concept to grasp, but you can overthink as well. So now that's probable cause. So now let's get to the Terry stop, the infamous Terry versus Ohio case. Um, it's interesting that it was a Halloween case. That's what we all called it in law school, the Halloween case, because it happened October 31st, where the police detective working in plain clothes uh, was downtown, and his attention was drawn to two men who he had seen before. Okay, and the detective had worked that area for 30 years and knew about shoplifters and so forth, and that he had not previously say he saw what drew his attention to these two guys, John Terry and Richard Chilton's. For some reason, I'm glad they called it Terry versus Ohio and not Chilton's versus Ohio. I don't know why. Maybe it's because I'm so inundated with it now. But the detective just observed, and he saw enough information, and he saw what they were doing, and they looked suspicious. Um, and I told somebody, I said that doesn't mean that they're guilty. That just means they look suspicious. And so he identified himself as a police officer and asked what they were doing. So he started asking them, and they began to mumble. Those are the kinds of things that could have been done in the old refrigerator case that we talked about in the second one. Could have, asked him some questions, and the person began to mumble. And I would submit that upon questioning, you probably would eventually raise it to the level of probable cause, and then go get the warrant, and then open the refrigerator. But anyway, detective grabbed Terry, spun him around. Notice what happened he did. He didn't go into his pockets. He patted his exterior clothing. Okay, that's what he did. He felt a pistol, and then he removed it. So he also patted the other guy down and found he had a revolver in an overcoat pocket. This was on the person of the individuals now. At no time did the detective reach into the clothing until, see, this is critical, the weapons were felt. And they were arrested and charged with carrying a concealed weapon. And so the defendants tried to suppress it, saying that that this was overreaching. The trial court said the difference between investigatory stop and frisk and between a frisk of outer clothing and a full-blown search, and the Supreme Court, the appellate court, affirmed the decision and denied the appeal. The United States Supreme Court agreed to hear the case, and they affirmed the lower court's findings. So it established what we called earlier, the Terry stop, and a real good tool that has been used, and then some statutes have been implemented in many jurisdictions. Those of you who took criminal law, we discussed that issue. And so the Earl Warren Court, which was a very liberal court, provided instructions for police officers as to what they are supposed to do. And this is critical and important, and it still stands today. It says, all we hold today is that where a police officer observes unusual conduct which leads them reasonably to conclude in light of experience that criminal activity may be afoot. I remember in law school that term, crime is afoot. Now, does anybody have any idea what that means, that crime is afoot? Because it became one that we cite and use quite frequently as defense, as prosecutors would use it, should I say, or we could use it too. What is crime afoot? Anybody know? Type in the chat, yes or no. Nobody? Well, sometimes. Okay, since no one knows, it's really right here in front of your face. When it says that the crime may be afoot, means it's right there up in your face. Afoot. It's a term that as if you go to, and I'm going to do it for you so I can tell you. Okay, it means very simply that the person is in the progress or preparing or happening or beginning to make something happen. That's what it means. Okay, so it means that they're in the actions or in the activity itself. That's what it means. Well, criminal activity may be afoot, and that the person which you're dealing with could possibly be armed. The key thing was for the protection of the officer. And so there were two weapons that were recovered, and so because this was a potentially dangerous situation for the officer, then it was for their safety that the search took place. Such a search is a reasonable search on the fourth, and any weapon seized can be properly introduced in evidence because of them simply patting it down. It's a bulky item. Everybody got it? So now you know what a foot is. The next time you hear it, it's not a part of the body. We always laughed about it. I remember my professor, he said crime is, and he drew the picture of a foot on the blackboard. I'll never forget it. Professor Enbow, that was the same guy that taught us about how he didn't like the Miranda warnings. But he's to get the point in our heads. I never forgot that picture of that foot. It says the stop may last as long as it reasonably makes the law enforcement officer um, to determine if activity was afoot. Okay, if it was taking place in their presence. So you can ask for the names and stuff like that. Many statutes says that you have to, and in Ohio is one of them, that you had to be able to produce ID and then an exterior pat down to ensure the person's not armed. Okay. And then they call um, um, many states, well, dealing with the Rodriguez, unreasonable extending the Terry detention stop without a more unconstitutional case was Rodriguez in 215. But many states, but what they did was they adopted 20-minute rules where a person is released if probable cause is not developed within that 20 minutes. That's a parameter, an idea, and it made a lot of sense. Okay, because earlier there was no definition of what a brief stop was and what the pat down was all about. Okay, so now you got both probable cause and you got the Terry stop, which means you got pretty much the essence of this whole week's lecture. So let's elaborate a little bit more on the Fourth Amendment warrant requirements. So what happens is an individual law enforcement officer where you establish that they have probable cause. They will then, rather than search, they will go to a judge or a judicial officer and complete an affidavit where they swear or affirm in that document under oath that facts support the warrant. And it's reviewed by the judge or magistrate. And if they agree then with the facts, they will authorize and sign the warrant. And so it means that the courts have to approve a warrant. You can't just go out and do it. The affidavit supporting a warrant must describe the place to be searched and the things. So you have to be really careful about how you craft your affidavit so that the warrant will, as it says here, if you read this very carefully, the light bulb should come on from last week. It says this particular clause requires law enforcement to clearly describe the place searched and minimize intrusion and to prevent, here we go, government overreach. Government overreach such as law enforcement merely rummaging through people's belongings. Okay, so does that rummaging through people's belongings, does that kind of fit the scenario in our discussion assignment from last week? It does it? I already answered that earlier. I know it does. Uh, okay, you all are delayed in that. I don't know. Boy, if you all were on Family Feud, boy, and you had to find the buttons, boy, you all would be losing. But anyway, it talks about the 1927 Marion case as we conclude this section. It talks about the Supreme Court discussed the particularity requirement and provide a rationale. So justices said the requirement of the Fourth Amendment that warrants shall be particularly descriptive of the things that you intend to seize or persons and prevent seizure of one thing under a warrant describing another. As to what is to be taken, nothing is left to the discretion of the officer executing the warrant. So they have to follow the warrant. So how the warrant is tailored is going to be very important. And then these are some things here that if you want to click on, you can go look at yourself. Sufficient particularly clause, I already kind of talked about that. The scope of the warrant refers to the boundaries of the search itself. And then the time frames. Time frame must be executed within a certain period of time. And oh man, they mentioned the knock and announce rule as part of the Fourth Amendment. And you know, or should know, that there's no knock warrant, does not require a knock announcement. The police were forcibly permitted to enter the structure. But you know, and I know that that warrant thing is under attack because of what case that we're familiar with or should know about. And many jurisdictions are doing away with the no knock. Anybody remember what was the name of the person? She lost her life in Kentucky. Breonna Taylor. Breonna Taylor. And so yeah, it's under attack, and law enforcement is looking at that right now. I don't like them because it creates bad situations all the way around. So anyway, you can take a look at that as well. All right. Warrant key terms. I'm just going to just mention this is something that you'll I'm not going to spend time on it, but I'm going to tell you that you can find it. The key flashcards, and it tells you unreasonable search and seizures, and it explains it and elaborates on it. Then you go to the next card, affidavit. Okay, next card. Okay, so I'm not going to spend time on those. You can go over those, but this is some information here to help you. So we're at the end here. We're coming right up on our stop, and it says these are the exceptions. Now you already have a jump start on this because of the information that I provided. Unless there is an exception, and then this gives some exceptions. We already talked about the Terry stop, but then the plain view exception, which kind of is self-descriptive. Important elements in the plain view are the law enforcement officer must be legally present, must be there legally. The discovery or observation of contraband is inadvertent, seems to be seized. So let's say, for example, if you, like going back to the scenario we had last week, if the person was on their way to the bathroom and they happened to pass by the refrigerator and the refrigerator was open and saw the head. Would they then have to go get a warrant before they seized it? No, because the person would probably move it because it's in plain view. It means what it says. There we go. And that's simple as that. So I can move on with that. Consent means what it says. It must be um, knowingly and voluntarily given. Okay, you come into my house and you're asking me, uh, can you check my house? Can you search my house? And I'm surrounded by you guys, police officers, and I say yes. What would you say if you were a defense lawyer about that? Yep, yep, yep. Because the person, it says one of the elements is that it must be um, voluntary, the given. Um, Elaboration on that kind of a little bit is that the person must be in a situation where they have a choice. Um, and you can read these cases, such as the Rodriguez case I was talking about earlier, um, in the Rudolph case. It says, although not required, obtaining consent in writing is another tool to demonstrate consent is knowingly and voluntarily given. Written consent forms are usually used by law enforcement for the purpose. Now that we have the presence of, as they say here, which is something that I think is really good, is cameras, dash, or body room can be used to document and demonstrate consent, and that is voluntarily given. I think that's probably one of the greatest things uh, to help both sides. Then we got the automobile exception, which, if you paid attention to the question that I asked you earlier, why was it smart for them to wait for the individual to get in the car? Is because of the automobile exception. Okay, and that um, it is important based upon the Carroll doctrine that permits law enforcement to search a vehicle incident to a lawful arrest. So, okay, so guess what? That person was speeding, number one. Number two, they established that he had a warrant out from that. And so um, if a person has those kind of situations applying, and I'm throwing some things in here just to help you a little bit, the doctrine was applied to passengers, and also it would be, of course, to the driver. Cocaine found inside a pocket coat owned by Belton, who was arrested. He objected to the search. The court affirmed the search and created a rule that the entire passenger compartment of any vehicle may be searched. There we go. Remember, they found the stuff in the glove compartment, and that's the key. So you got the automobile exception, so you're aware of that. Okay. Search incident to an arrest. This is based upon a lawful arrest, where a person's arrested and you can search the immediate areas um, under their control. Okay. And then we talk about probation and parole searches. Um, they're different. It's you don't enjoy the same protections as individuals who are not. And you check Griffith versus Wisconsin, you'll know what I'm talking about, and these other two cases here. Garbage. Um, a person's garbage is a policeman's treasure. There are no reasonable expectations of privacy in garbage set out for collection. Does that make sense to you? Yeah, yeah, it is funny, but yes, it seriously is. I remember a case where we had to assist in going through some garbage to try to find some drugs. And oh man, there was some stuff in that garbage can. We had gloves on and all of that stuff. But it was established in 88. It's funny because in 89 is when I became a police officer. And I remember that California versus Greenwood, in which the court established the garbage, we called it the policeman garbage search rule. That's what we called it. And but uh, it it is it is a law that makes a whole lot of sense. There have been many individuals who were convicted because of their garbage, and they tried to say that you had to get a warrant to search their garbage. No. Um, if you are a individual who is committing identity fraud, you heard of dumpster diving? Everybody heard of dumpster diving? Yeah. And all that means is that when you throw stuff away, just either shred it or tear it up so bad. I get my new credit card sometimes. If I cut them up, I cut them up and I put in one garbage can some of the other, some parts of it. And I won't put the whole thing in there because a person can piece it together. But dumpster diving, you can go and find stuff. Okay, the automobile exception, so on down. Well, that's it for me. I hope that you got a lot of good stuff to help you out. You should be, well, with this, the exceptions and all of that. You had already had a head start, so I'm going to adjourn for the evening. But before I do that, I'm going to see if anybody's sharp enough to pick out um, a key phrase. Actually, the way I do them, if you pay attention to, I do it based on the lecture. I'm looking at the chat box. Any suggestions? You can eliminate the one from last week. Okay, we're not using that one again, even though we talked about it today. Any shots? 5, 4, 3, 2, 1. Reasonable suspicion. That's it. Give me reasonable suspicion and you get your points. Okay? Well, this has been a very interesting lecture. I hope you got some stuff that elaborates and helps you to understand what this whole topic was all about. And you got some tools. Any questions before I adjourn? You're all pretty quiet tonight. Are you all, are you there? Or I'm by myself? Sometimes the only time I know you're there, and I don't want to keep the mics open up because we have all kind of noise, but um, is to see what you say in the chat box. And no one's typed anything in the chat box since 7:35. Oh, okay. Oh, maybe that's my bad. Maybe I haven't scrolled down. Oh, that is okay. Reasonable suspicion. Mm-hmm. You got it. Okay, I had to look down. Sometimes that's my bad. Yes, actually, they got DNA from it. Yeah. Okay. No, we're not gonna use, but it's yeah, it's reasonable suspicion. That's it. So, okay, you guys got it. So, all right, I'll see you next week. Uh, Somebody said there's a lawsuit going on. Oh, Brian, officer was on high-speed chase and killed a 6-year-old who ran. Yeah, the we talked about. You remember in the criminal law classes that we talked about high-speed chases and that the policies that departments have in place because they are very dangerous to both the public as well as the officer themselves. Remember that? Do you remember that, Brian? Yeah. So because that happens, it's that's why the policies are in place. You can remember the infamous the high-speed chase that we all saw on TV where the car was boxed in. Does anybody remember the name of the case that the famous boxed in Bronco was involved in the chase? Yeah, okay. Yeah, that was it. That was it. But yeah, there are techniques, and like I said again, when you take the introduction to criminal law class that I cover in one of those modules. Okay, it's overtime. I'm going to say good night to you guys. Thank you for hanging out with me again. See you guys next week at 7 o'clock p.m. Get those assignments in. And again, you know the parameters and rules about reaching out to me. Uh, all right. See you later. Have a good one. Stay safe.